A Senate Finance Committee hearing turned into a sharp clash over a controversial IRS settlement involving President Trump and his business interests. Senator Ray Luján questioned Treasury Secretary Scott Bessent about allegations that a legal agreement provides unusually broad protections for the president, while Bessent defended the government's actions and repeatedly pointed to ongoing litigation. Watch the exchange first, then we'll break down the competing claims, what was actually being debated, and why both sides strongly disagree about the meaning of the settlement.
Secretary Bessent, should Americans who illegally evade their taxes be investigated and prosecuted?
Yes.
Secretary Bessent, should people and organizations facilitating money laundering for Iran, North Korea, or Hamas be prosecuted?
Yes.
What about laundering money for Mexican drug cartels?
Yes.
Should a person who traded and profited on insider information be prosecuted?
According to the law, they should.
Appreciate that. Mr. Secretary, as a result of President Trump's $10 billion lawsuit, the Department of Justice, on behalf of your department, settled with President Trump by creating a $1.776 billion slush fund to pay for his supporters and criminals. Were you either directly or through your staff asked to sign the original agreement?
Senator, you were not here at the early part of the meeting.
I saw you on TV.
Well, congratulations, and you would know that I'm unable to answer those questions, and they should be referred to
Mr. Secretary, what about the addendum to this agreement? Are you familiar with what the addendum is?
I'm not sure what you're referring to.
Are you familiar with this giveaway from the IRS that says President Trump and anyone that knows him or does business with him or part of a business, they get off scot-free? Are you aware of this?
Again, I refer you to Attorney General Blanche.
Are you Attorney General Blanche's client?
The IRS and Treasury are a client of the Department of Justice.
So is that a nice way of saying yes? You're a client. He's your lawyer.
He represents.
You're the secretary. Are you the Secretary of Treasury? Yes is the answer.
The Department of Justice.
Scott Bessent, let me ask you this question, sir. Are you the Secretary?
In my personal capacity, Tom Blanche is not my attorney.
Correct, sir.
Are you, sir, for the
Mr.
U.S.
Secretary,
Treasury?
Scott, let me ask it this way. Scott, are you the Secretary of Treasury for the United States government?
Yes.
Appreciate that. The Department of Justice represents the IRS and the Department of Treasury in this lawsuit, correct?
Correct.
Are you aware of this addendum? You're telling me DOJ gave the president this without you knowing about it?
Again, they settle on our behalf.
Well, that's not how the law works, sir. I'm not a lawyer, but you have a bunch of them behind you. You should see the faces they're making at me behind you. They're all scowling at me back over here.
Well, I think that's a different reason, sir.
Well, for whatever it is, they're doing it. Mr. Secretary, my concern is that this addendum's not been getting a lot of attention. There's colleagues on this panel that think this slush fund is a bunch of bullshit. And they've called out to say, get rid of it. Now, people need to say, are you okay with one person in America, because the Secretary of Treasury, I'm guessing, conferred with the Department of Justice, because you're named on this lawsuit, sir. These are all the transactions from the president as well, that I'm going to ask you this next question as well. You were bragging to one of my colleagues that you've been sanctioning people doing bad things in America. People that get sanctioned, like Iran or terrorists, they're told not to do business in the United States with partners. Is that your understanding, sir, me as a layman?
It is.
You hold these bad people accountable. I congratulate you for that. So this little giveaway to President Trump and his family gets them off scot-free. Does every American become part of this addendum? If someone didn't pay their taxes or violated tax law or did bad things, are they told, can't prosecute you, you're good? Everyone going back to the date of this, or is this only for President Trump and his affiliates?
Senator, do you have specific knowledge that President Trump's being audited?
Sir, I have specific knowledge of this addendum that you don't know a damn thing about. That is for the Department of Treasury that your lawyer at the Department of Justice signed you up for. The reason I'm asking this question is because President Trump's sons signed a deal, as you know, with World Liberty Financial with a bunch of folks you sanctioned. And now as part of this, there's an addendum that says President Trump and his kids and anyone affiliated with him, I don't know if it's current wives, former wives, people that just did transactions with him, they're off scot-free. That, you know, that has a new way, a new ring to it, this thing, scot-free, because the Department of Treasury and the IRS is not going to go after him, sir. This is wrong. This is lawless. I hope our colleagues will look at this addendum. If I could offer this into the record, Mr. Chairman, for those that haven't seen it yet.
Without objection.
Come on, man. There's a better way of doing this, sir. That's all we're saying here. So, look, I appreciate it if you don't want to talk about a lawsuit. That's your prerogative to answer that way. But to say that you as a client, as Secretary of the U.S. Treasury, does not know what the Department of Justice is giving away to people, come on, man. That's just not on the up and up, sir. I hope we can do better. You don't understand
the way the protocol works, and we receive advice and accept their settlement.
You're telling me as the Secretary of U.S. Treasury, you don't know that the President of the United States, who I think you work for, got a sweetheart deal from the Department of Justice, who's your lawyer.
I do know.
You're in line for the presidency, Scott.
I do know that the President of the United States and 400, many of his employees had the largest tax leak in history. And I know, here's his filing, sir, of all the insider trading, right here. Do you want to apologize on behalf of the American government?
Scott, you should apologize to the American people for fleecing them and giving this away to Donald Trump, man. That's what you should do.
We can agree to disagree.
Senator Warnock.
Thanks. That we'll agree on.
This hearing exchange was not merely a dispute over legal paperwork. It reflected a broader argument about government transparency, presidential accountability, the limits of executive power, and how settlements involving public officials should be viewed by the American public. At the center of the confrontation was a settlement connected to litigation involving President Trump, the Internal Revenue Service, and the Department of Justice. Senator Ray Luján repeatedly focused on what he described as an addendum or provision that he believed granted unusually broad protections to President Trump, members of his family, and potentially affiliated entities. Treasury Secretary Scott Bessent strongly rejected that characterization. Understanding this exchange requires separating political rhetoric from the underlying issues being debated. Luján's primary argument was straightforward. He argued that ordinary Americans are expected to comply with tax laws, face audits when necessary, and remain subject to enforcement actions if authorities believe violations have occurred. His concern was that the settlement appeared to create a different standard for the president and individuals connected to him. Throughout the hearing, Luján repeatedly returned to a basic fairness question. Would similar protections be available to any other taxpayer? Or were these protections unique? That line of questioning formed the core of his argument. From his perspective, even the appearance of unequal treatment is problematic because public trust in tax enforcement depends on the belief that the same rules apply to everyone. Bessent responded very differently. Rather than accepting Luján's characterization, he argued that the senator was fundamentally misunderstanding how settlements between taxpayers and the IRS often work. Bessent repeatedly suggested that settlement agreements routinely include provisions addressing ongoing disputes, audits, claims, and litigation. His position was that the agreement did not provide blanket immunity and did not exempt anyone from future legal obligations. This distinction became the central dispute. One side argued the settlement functioned as special protection. The other side argued it was a routine legal mechanism used to resolve existing disputes. That disagreement is important because it reflects two completely different interpretations of the same documents. Another significant aspect of the hearing involved accountability and oversight. Luján appeared frustrated that Bessent repeatedly referred questions to the Department of Justice. The senator's position was that because Treasury and the IRS were involved, Treasury officials should be able to explain the agreement directly. Bessent, however, emphasized that the Department of Justice represented Treasury and the IRS in the litigation. As a result, he maintained that many detailed legal questions should be directed to government attorneys handling the case. This type of conflict frequently emerges during congressional oversight hearings. Lawmakers often want direct answers from agency officials. Agency officials, meanwhile, frequently cite ongoing litigation, attorney-client relationships within government, or legal constraints that limit what they are willing to discuss publicly. As a result, hearings often become debates not only about the underlying issue but also about who bears responsibility for explaining government decisions. One of the most notable moments occurred when Luján challenged the idea that Treasury leadership could be unaware of specific legal arrangements negotiated by government lawyers. His argument was essentially that such a significant settlement involving a sitting president should not be treated as routine paperwork. The implication was that senior officials should know exactly what was agreed to and should be prepared to defend those decisions publicly. Bessent pushed back by emphasizing the extraordinary circumstances surrounding the original dispute. He repeatedly referenced the unauthorized disclosure of tax information and described it as one of the largest tax-related data leaks in American history. This response highlighted another important dimension of the controversy. Supporters of the settlement may view it primarily as a response to alleged government failures involving confidential taxpayer information. Critics may view it primarily as a question of accountability and equal treatment. The lens through which a person views the case often determines how they evaluate the settlement itself. The hearing also illustrated how political narratives shape public understanding of legal disputes. Luján used phrases such as sweetheart deal, giveaway, and scot-free. Those phrases are designed to communicate a particular interpretation to the public. Bessent, by contrast, used terms such as settlement, ongoing litigation, and standard procedure. Those terms communicate a very different interpretation. Neither side was simply discussing legal language. Both were competing to define how the public understands the issue. That is a common feature of congressional hearings. Beyond the specific settlement, the exchange touched on a broader constitutional principle. Democratic governments depend heavily on public confidence that laws are enforced fairly. When citizens believe certain individuals receive special treatment, trust in institutions can weaken. At the same time, governments also require mechanisms for resolving disputes through settlements rather than endless litigation. The challenge is balancing those competing interests while maintaining transparency and credibility. Another important point involves the distinction between immunity and settlement. These terms are often used interchangeably in political debates, but legally they are not necessarily the same thing. Immunity generally implies protection from prosecution or legal consequences under specified circumstances. A settlement, by contrast, is typically an agreement that resolves existing disputes. The central disagreement in this hearing was whether the settlement effectively operated like immunity or whether it simply resolved specific claims already under dispute. That question remains the key issue behind the argument. The hearing also demonstrated how difficult it can be for the public to evaluate complex legal agreements. Most viewers do not have access to all underlying documents. Even when documents are available, legal language can be highly technical. As a result, public understanding often depends on how elected officials, lawyers, and media organizations interpret those documents. This creates an environment where competing narratives can emerge quickly. One narrative emphasizes fairness concerns and potential preferential treatment. The other emphasizes legal procedure and settlement practices. Both narratives were visible throughout this exchange. The political significance of the hearing extends beyond the specific lawsuit. Questions involving presidential accountability, tax enforcement, and executive authority have become recurring themes in American politics. Any controversy involving those subjects tends to attract substantial public attention because it touches on larger debates about government power and institutional trust. By the end of the hearing, neither side appeared persuaded by the other's arguments. Luján remained convinced that the settlement deserved greater scrutiny and raised serious concerns about unequal treatment. Bessent remained convinced that the settlement was being mischaracterized and that critics were misunderstanding its legal function. As a result, the hearing produced more clarity about the disagreement itself than about the final answer. What viewers ultimately witnessed was not simply a dispute about one document. It was a larger argument about transparency, accountability, legal authority, and public confidence in government institutions. Those issues help explain why the exchange became so contentious and why debates over settlements involving public officials often generate intense political attention. Whether one agrees more with Luján's concerns or Bessent's defense, the hearing highlighted an enduring question that extends far beyond this single case. How should governments balance legal settlements, taxpayer rights, executive authority, and public accountability while maintaining trust in the fairness of the system itself?